Hi everyone, this is Mechaella Nonato from BS Psychology 1A, and today we are going to talk about legal matters. So now let's start with the discussion. According to Brian A. Garner, he was an American teacher on legal writing. Your readers are the ones finally who matter. You have invited them to attend your words. You seek their precious time, and you may even expect to be paid for your efforts. Courtesy requires that you show your readers some grace and consideration. This is the golden rule of writing. It says that write to others as you would want others to write to you. Let us now define what is legal writing. So legal writing is the type of writing used for documents that relate to legal matters. Now, what is legal matters? Legal matter means any dispute regarding the rights or obligations of a party that arise out or relate to the existence, negotiation, validity, formation, interpretation, breach, performance, or application of this agreement or any ancillary agreement. It means any administrative proceeding, case, group of cases, or legal issue for which the state requires legal representation or advice. So the foremost aim of legal writing is to communicate. There is here an obligation of courtesy. The writer must always consider the reader's comfort and convenience in mind. So whether you considered yourself a writer or not, legal writing is a necessary and important skill required for all legal professionals. From paralegals to lawyers to secretaries, legal writing is applicable to every legal professionals. It is usually to persuade. The tone and style you'll use depends on who you're writing for. As a legal writer, you should be able to switch between the legalese required for officials such as judge and plain language required for a client. And whether you're a confident writer or not, legal writing is an important skill for any lawyer in any practice area, from court documents like motions, discovery documents, briefs, and memoranda to in-office communication like letters, client emails, internal memos, and more. There's a whole lot of writing. Lawyers also need to ensure the writing style, tone, and voice in legal documents, and communication are appropriate for a wide range of audiences such as courts, judges, and clients. Documents filed at court, including briefs and memoranda, involve researching facts and cases, analyzing situation, presenting information, and making an argument. To be a skilled legal writer, lawyers need to be authoritative, credible, and persuasive in their writing. And legal writing must be written at clear, concise, and professional level, too ambitious yet somehow misguided. It articulates the way people interact with the rules which govern society in an understandable and thorough manner. So here are the legal writing tips to help you get started. First, you must understand your purpose. Ask yourself, why are you writing this? What are you hoping to accomplish? What is the outcome you wish to achieve? Writing a contract may serve to inform, while court documentation may serve to persuade, and client intake documentation may serve to evaluate. The structure, tone, and voice of the document will change depending on the purpose of your legal writing. Understanding that purpose will help you write better. So tip number 2, understand your audience. Knowing who you're writing for will help shape the structure and tone of your piece. A judge, another attorney, including an opposing attorney or client, will have different experiences and expectations that inform how they read your work. When it comes to your audience, keep the following in mind. First, their role and relationship to you. Next, their age, income, economic status, level of education, values, and how much they already know about what you're writing about. This will help you determine the tone, style, and level of detail to include in your writing. So number 3, do your research. Good legal writing requires researching and incorporating relevant legal precedents in your documents. Before you start writing, thoroughly read any material provided to better understand the legal issues. Every case and document is different, but keeping some basic rules for legal research in mind will set up you for success. Now, depending on the piece of your writing, you may also find the secondary sources such as legal dictionaries, law reports, and academic journals helpful in your research. For example, you'll need both the primary and secondary sources to establish mandatory and persuasive authority. So for our tip number 4, you have to create an outline. One of the most helpful legal writing tips to improve your legal writing skills is organizing your research into an outline. Starting with an outline will help keep your writing organized and focused. A good outline starts by detailing the topic, putting the most important information at the top. Then, flesh out the main points with the supporting details while making sure the transitions between points make sense. Legal writing becomes much easier and less intimidating once you have an outline to help organize and guide your writing process. So for our tip number 5, put your words on the page. Even with a detailed outline, getting started can be difficult. Writer block is a real thing that even the most seasoned legal writers suffer from. But don't worry about getting it perfect on the first try. That is what editing and proofing are for. On your first draft, focus on capturing the right information. Make sure the information is complete and sufficient, and the content flows nicely from one section to the next. Give yourself as many drafts as you need before your deadline. Also, give your writing some room to breathe by taking a break and coming back with it with your fresh eye. Always remember that you can clean your writing up in the editing stage. You don't have to get the formatting perfect on your first try. So for our tip number 5, put your words on the page. Even with a detailed outline, getting started can be difficult. Writer block is a real thing that even the most seasoned legal writers suffer from. But don't worry about getting it perfect on the first try. That is what editing and proofing are for. On your first draft, focus on capturing the right information. Make sure the information is complete and sufficient, and the content flows nicely from one section to the next. Give yourself as many drafts as you need before your deadline. Also, give your writing some room to breathe by taking a break and coming back with it with your fresh eye. Always remember that you can clean your writing up in the editing stage. You don't have to get the formatting perfect on your first try. Tip number 6. Be aware of content structure. The best way to structure any piece is by writing from the top down. Start by showing the reader what you're writing about and why. Then provide the arguments to support your case. Pick your best or most persuasive arguments to focus your writing on. Then filter additional supporting arguments thereafter. Use headings to break up sections and transition from one argument to the next. And start new sections with summary sentences. Where appropriate, it may also be helpful to use lists and bullets to make your writing scannable for the reader. Number 7, be clear. When writing any type of legal document, state your point directly and clearly within the first few sentences to help guide the reader along. Assume the reader has very little time or patience that they hate to read and that they're only going to read the first 200 words. What you say in those 200 words will help them decide to continue reading. Tip number 8, use jargon only when appropriate. Using jargon, including legal terms, is only appropriate in some contexts. For example, using too much legalese with a client who is not well versed in specific legal matters may end up confusing them and muddling the conversation with unnecessary questions. While in court documents, it's completely appropriate and sometimes even necessary to use the correct jargon and terminology, since another attorney, judge, or magistrate will be your reader. When appropriate, strive to use plain language in your legal writing while showing that you understand jargon and can present it in easy to understand ways for the reader. Tip number 9, edit and proofread. The legal writing process doesn't just stop when the piece is finished. One of the most mistakes writers make is not budgeting for the editing phase. A thorough editing and review process takes time. It's usually helpful to have somebody else edit and proofread your work, but you should be able to take care of the basics yourself. Master spelling and grammar basics. Lawyers who present document with spelling and grammatical errors will be seen as less credible and lacking in attention to detail. Understandably, it can be difficult to catch spelling and grammatical errors immediately. Once you read your document several times, you'll usually glaze over your own mistakes. Some other helpful legal writing tips for the editing process include reading your writing aloud or reading it backwards to help hone your focus and spot errors you'd otherwise miss. And for the tip number 10, use helpful tools and apps. No matter what medium or document you're writing, all good writers should always use spell check at a minimum. Advances in writing technology have also made legal writing much easier. For example, writing apps like Grammarly and Ginger can help you catch grammar, spelling, and other language mistakes. If you don't have an editor always available to help proofread your legal writing, which most usually don't, text-to-speech apps such as LinguaTech and Natural Reader can help you read your documents out loud. This will help spot errors and awkward passages. And the last but not the least, read other writers' work. The most common piece of advice writers to give to those looking to improve their writing skills is to read. This rings true for any kind of writing. To improve your legal writing skills, specifically, find good legal and business writers and read their work. This could be legal documents, but also books, blogs, and articles. By studying and understanding how others write and structure their pieces, you'll get a feel for the general format of a legal document. You can then incorporate your unique ideas and writing style. You could also ask colleagues for examples of their work or join communities and forums. And now let's proceed to the prototypical types or examples of legal writing. First, we have the legal memoranda. It is a document used in legal practice to identify and advise on the legal issues in a client's case. It is also a common type of assessment in law degree. Inter-office memos. It is a message sent between the different departments of a company. We also have letters. It is a formal written request by a court in a foreign jurisdiction to summon and examine a witness in accordance with that jurisdiction's procedures as oral interrogatories. Next, we have briefs. It is a short synopsis of a case. We have the motions. It is a written request or proposal to the court to obtain and ask for order, ruling, or direction. Next is judicial opinions. It presents a court's interpretation and application of existing law to a particular dispute or its creation of new law. Persuasive writing. It is a written advocacy. It supports the client's legal position and move your reader to agree with the legal conclusion that benefits your client. Legal drafts such as contracts and wills will fall under this type. So, the citations format are required by court in all memoranda or briefs filed. online and storage, library-based law collections have made it easy for legal personnel to access references and research materials, which has influenced the citation norms. So this is the ethics and legal writing. All legal practitioners should keep in mind the proper ethics of the profession. Ethical violations do not just mar on one's career but also damage the client in his business. Legal writers are duty-bound to understand and rally against frivolous legal writing, ghostwriting, and plagiarism.